Hello and welcome to the Christmas edition of the Herrington Carmichael Employment Law Update. As always, I've got the latest things for you in the world of employment law, and as you can see, this month I'm on location. So, where do we start? We start with the case of AWAN and ICTS. This case relates to disability benefits, where your employer gives a long-term insurance policy to an employee in relation to ill health. In this case, Mr. Alban was dismissed following a cheapy transfer where he derived that benefit in his employment. He was dismissed on grounds of long-term incapability. He pursued a claim. Along came the EAT, and the EAT said that he shouldn't have been dismissed because he couldn't access that benefit. Now, this is a pretty well-established issue, but it's a good reminder for employers. Because if you've got long-term benefits, if you've got employees who are on sick leave, getting those benefits or the potential for those benefits, you need to be really careful. Next, the case of the British Airways and Pinot. This is a case we've talked about before. In this case, it relates to part-time worker less favourable treatment. And in this case, the claimant, who was a member of a number of different claimants pursuing British Airways for the same issue, argued that they worked 53.5% of the time but only received 50% of the pay. It was part-time worker less favourable treatment, and they've succeeded again in the Court of Appeal. We expect this to be appealed again, but it does seem like good law. If somebody's working half the time, they should get half the pay. If they're working 53% of the time, they should get 53% of the pay. Number 3 this month, Ball and First Essex Bus Company. This relates to drug testing. In this case, Mr. Ball failed a drug test, but he came along and he presented alternative evidence. The bus company didn't take it into account. It's a classic situation of investigation in a misconduct proceedings. What the bus company should have done is to take that into account, and as a result we could have resulted in a different dismissal decision. It wasn't a reasonable investigation. For employers, you need to investigate carefully. If the employee comes along and they give you alternative evidence, you actually have to look at it. Finally, the case of Wood and Durham County Council. This was quite a sad case which related to somebody who suffered from post-traumatic stress disorder and argued that as a consequence of that they had a tendency to steal and actually stole items from boots. In this scenario, the individual managed to fail a series of compliance checks as a consequence of that incident. What happened is they were dismissed, they pursued a discrimination claim. Now, tendency to steal is excluded from what is a disability. As a result, the case did not succeed, but it's a really fine line. It's really careful for employers here who have employees who suffer quite unique symptoms as a consequence of a disability. And it does mean you need to take some careful legal advice. That's it from me this month. I wish you all a very Merry Christmas and a Happy New Year from myself and everyone at Herrington Carmichael, and we'll be back with you in January. Thank you.